Plaise à la cour, Mr. President, honorable judges. It is both an honor and a privilege for me to stand up before you this morning in this courtroom. As you know, I have been associated with this tribunal for many, many years. Not as many as my colleague from the prosecution, but quite close. And I believe in the work of this tribunal. Of course, there have been and there continues to be frustrations in working before this tribunal. And I'm sure you will agree with me, Mr. President, that it is not easy to be a defense counsel before the ICTY. I think this is due mostly because of the nature and the objective gravity of the charges and the accusations which are adjudicated before the ICTY. What I can say, however, without any hesitation, is that I am proud to be here this morning. And the main reason why I am so proud, it's because I believe in the work I do. I believe in the necessity of this work, and I believe that there is an absolute requirement for defense counsel. Contrary to popular belief, it is not because you are accused before the ICTY that you are guilty. It must be, and it is possible, for an accused to be acquitted of charges if these charges are not proven beyond a reasonable doubt. Today it is my duty to introduce the case for the defense of Second Lieutenant Drago Nikolić. And I am accompanied for this purpose this morning by Mrs. Jelena Nikolić and by Bojan Stefanovic. Now you heard me right, Mr. President. I said Second Lieutenant Drago Nikolić. I did not say general. I did not say colonel. And I did not say lieutenant colonel, major, or captain. In fact, I did not even say lieutenant. I said Second Lieutenant Drago Nikolić. A man accused of conspiracy to commit genocide. Now this is significant. As you may also know, I spent many years in the military, more than 20 as a matter of fact, and I have no doubt in telling you this morning that there is very little a second lieutenant can do in any army of the world in terms of deciding the course of action of this army. My aim in presenting this opening statement this morning, of course, is to provide you with an overview of what can be expected to be presented and what we will hear during this trial in relation to Second Lieutenant Nikolić. To begin, there are two preliminary issues I would like to raise. The first one being the prosecutor's address before my colleague took the floor from the prosecution. Now, Mrs. Del Ponte, what did she say? Well, she said something that cannot be denied as we begin this trial, and that is that many persons were killed in the Srebrenica area in July 1995. And that what happened in that region can be described as anything, cannot be described as anything less than a tragedy. Now, we don't agree that this is a genocide. And we don't agree with the numbers of unlawfully killed persons or victims as alleged by the prosecutor. But a tragedy it was. That is undisputable, and we offer our most sincere condolences and support to the families which are broken as a result. In this, Mr. President, honorable judges, we fully agree with Madam Prosecutor Del Ponte. Where we also agree with her is that the crimes associated with Srebrenica must not be imputed on the Bosnian Serbs as a people, nor on the army of Republika Srpska as an organization, nor on any other entity or group, but solely on individuals. Individual criminal responsibility is the business of this tribunal, and it is also the aim of this tribunal. And at the end of the day, at the end of this trial, none of the accused who stand here before you should be held accountable unless it is proven beyond a reasonable doubt, and I weigh my words, that they personally and individually committed the crimes they are charged with. Proof beyond a reasonable doubt. Words highly familiar to anyone who has studied law in any way. But also, regrettably, Mr. President, words the meaning of which is often misunderstood, if not forgotten, by many jurists, and that is for various reasons. Now, unfortunately, in this case, despite the prosecutor's statement or reassurance that no organization is on trial here, this is not what stems from the prosecution's strategy, nor from the prosecution's opening statement. I'll get back to this a little later when I address the issue of joint criminal enterprise, which, strangely, yes, but understandably, was not even mentioned once by my colleague from the prosecution during his opening statement. Allow me, Mr. President, simply to make a quick reference to the opening statement where my colleague from the prosecution stated, "We don't believe the Serbs' story." That was when he was discussing the alleged involvement of one of the accused in this case. And there was a story about somebody grabbing a gun and getting his hands burned. It's not the witness that the prosecution doesn't believe. Fortunately, it is the Serb story that is significant, and this is not right. The second preliminary issue I wish to address at this time is the reason why we decided to address Your Honors this morning at the beginning of the trial and not to wait until the end of the prosecution's case. Of course, this is our choice, and we exercise our option to do it today. But why do we decide to do so? We debated the issue. It's a matter of strategy. There are many theories, and it is not an easy decision to decide to do this opening statement today. The fact that we are appearing before professional judges is, of course, a major consideration. I'd like to share with you the two governing factors that made us decide to go before you today with this opening statement. The first one is the unique character of this case. Why is this case so unique? Well, it's unique because it has received worldwide media attention. Maybe using the word "this case" is not the right word to use, but the events in Srebrenica have certainly received worldwide media attention. Two previous trials have been held in which a general, commander of the Drina Corps, General Krstić, was found guilty, and a second trial was held during which the commander of the Bratunac Brigade, Colonel Blagojevic, and the chief of the engineers within the Zvornik Brigade, and that is Jukic, were both found guilty. The prosecutor has labeled this, the events of Srebrenica as the largest killing operation in Europe. What we want to avoid is simply to consider that because there have been past trials, this trial will be the same and that its result will be the same. I mentioned in the pretrial brief the SALT principle, or guilt based on same as last trial. Unless guilt has been proven in this case, in this trial, then there is no guilt. This is a different trial. My colleague from the prosecution also mentioned that no one will be left untouched by the proceedings here. And I agree with him. We will see horrible pictures, and we will hear some pretty ugly stories. But it is our duty, everyone here in this courtroom, to get over these pictures and to assess what we are here to assess, and that is the alleged responsibility of the people who stand accused before you. Now, there are a number of co-accused in this case, and that also makes this case quite unique. Beyond any doubt, the prosecution would like to sit there and to watch the co-accused in this case take on each other and fight each other, and he can just sit and wait for a guilty verdict. This is probably the strongest aspect of his case, at least in his view. But it would not be right for the prosecution to try and prove its case in this manner. The onus and the burden is on the prosecution to prove this case. Now, these are the things that make this case unique, and this is the first governing factor why we decided to go today. The second one is that we decided to alert the trial chamber from the beginning of the case on the following. First, the other side of the story. This will be a long trial. Much of the evidence for the defense will come in during the prosecution phase. It will come in through cross-examinations, and it will come in by the prosecution's own witnesses. There are weaknesses in the prosecution's case, and there are potential traps to be avoided by all. That is why we decided that it was necessary for us to alert you of these issues before the beginning of the trial. Now, I was listening, of course, as you were, to my colleague from the prosecution on Monday and Tuesday. And it is clear when you listen to the prosecution that it has lost its objectivity. Every bit of evidence, every document is being seen, analyzed, and interpreted against the accused without any consideration for the opposite view. But this is not surprising. It's the prosecution's duty. As Madame Del Ponte said, on behalf of the international community, to prosecute persons alleged to be the most responsible. Now, even though we will again and again hear from the prosecution that they are here to establish the truth, we should not be misled. This is not so. The prosecution is here to prosecute, and it will do everything in its power to ensure that the persons who stand before you today are found guilty.
Your Honor, I object. I object. This is a direct attack on the ethics of the prosecution. I object at this time because if this kind of personal attacks are allowed to continue, this trial will become a travesty and a circus. And if it's allowed now, it'll continue and continue and continue. And it's just completely unsubstantiated and uncalled for.
I take it that the word you're taking objection at is the misled, that prosecution is being attributed
He
misleading.
said that we're not looking for the truth. We're looking to mislead you and prosecute people with no regard for the truth. Okay. That's what he said.
Right, thank you.
And that is outrageous. If it's allowed to continue, it will corrupt the system and it'll become a circus.
Okay, let's have a consultation. Mr. Bougon, it's the agreement here, unanimous agreement, that you should approach your criticism of the prosecution in a completely different manner. We wouldn't like you to repeat what you have said, basically that the prosecution is deliberately seeking to mislead the trial chamber by and also not being interested in seeking the truth. I think that's an attack on the integrity of the prosecution, which should be avoided. And I'm sure that you are capable of avoiding and addressing these issues the same way you did. So.
Thank you, Mr. President. I would like simply to say that I do not believe that I've said anything outrageous. I did not say that the prosecution is trying to mislead. I said that we should not be misled and what the role of the duty of the prosecution was. And I also said that the prosecution would do everything in its power. I did not say that the prosecution was doing something illegal. I did not say that the prosecution was not having integrity. And I don't really appreciate, as was said by my colleague, being interrupted by Mr. Murkowski during my opening statement when I did not say anything wrong. However, Mr. President, if you believe that I did go beyond what is proper for this opening statement, I gladly accept your ruling and will refrain from any further comments in this way in the future.
We are sure you will, Mr. Bougon. Let's proceed. Thank you.
Thank you, Mr. President. I continue my opening statement simply by saying that facing the prosecution, nonetheless, you have the defense. And the aim of the defense, of course, is to try and balance things out. But more importantly, Mr. President, there is you, the trial chamber, whose duty it is to assess and weigh the evidence with a view to deciding if the accused before you today, if Second Lieutenant Drago Nikolić bears any criminal responsibility for what happened in Srebrenica area in 1995. And that's why we decided to do our opening statement, to ensure that every bit, every iota of evidence, as it is admitted in this trial, whether in the form of documents, witness testimony, or other, is assessed in full knowledge that there are two opposing theories in this case. Now, I refer to you to this picture on your screen. This, Mr. President, is the boring figure. It's a drawing dating back to 1915. You may have recognized the young lady on this drawing. Unless, of course, you recognize the old lady with her chin down in her collar. This picture, which really contains two images, was made to show that the human brain can only recognize one of the two images at a time. But just as for the prosecution's theory, there is another story behind what the prosecution would like you to see exclusively. Whenever the prosecution will show you the young lady, we respectfully submit that we must also be looking for the old. And when the prosecution will be attempting to show you the old lady, we respectfully submit that we must also look for the young. This is a critical aspect of this case. With this in mind, I now turn to the outline of my opening statement, which is displayed on the screen before you, divided into two parts. In the first part, I would like to address some of the highlights in the prosecution opening statements, to discuss the accused, Drago Nikolić, who he is, and to look at the case against Drago Nikolić so that we are clear about what the issues are in this case. In the second part, after a brief break, if you allow for such a break, then we will look at the applicable law, we will look at the prosecution's theory and the case for the defense, and finally I will conclude by looking at the evidence which you will hear in this case from both parties. Moving straight on to the first topic, highlights of the prosecution's opening statement. It's not my intention to spend too much time more on the prosecution's opening statement, but there are some issues which must be mentioned before we hear the first witness. Firstly, although my colleague spoke for some hours, I would not be surprised at this case if the trial chamber was somewhat worried, as the prosecution's statement appears, with all due respect, and at least in our view, rather thin. Even though I suspect that my colleague may have done this on purpose, this is nonetheless revealing at this stage. The prosecution does have a theory, but very little relevant evidence was referred to in support of this story. This is very much like its pretrial brief, the telling of a tragedy supported by exhibits which were presented in other cases, but without reference to exhibits in this case. Not surprisingly, the interpretation offered at this stage is very much one-sided. And on this, I join my colleague representing the accused, Beara, that there are indeed other reasonable and more plausible interpretations to these documents, as the evidence will show. Strikingly, other than to say that one of its witnesses is a bold-faced liar, and warning the trial chamber that witnesses will go back and forth, not telling the truth, very little reference has been made to witness evidence. More importantly, the theme of the prosecution's case was described on the basis of a document as being the success of the VRS in Srebrenica, Jepa, and other fronts. While this has little to do with Second Lieutenant Nikolić as an individual, it certainly has something to do with him as a member of the VRS. Simply put, Mr. President, the evidence will show that the success of the VRS from a military standpoint is not a joint criminal enterprise. Amazingly, and as mentioned earlier, these words, joint criminal enterprise, the focus and the skeleton of the prosecution's theory, without which this trial would be entirely different, have been omitted altogether from the opening statement. As we will see, this is significant. As for other highlights, which we believe the trial chamber must be made aware of at this stage, these include the following. First, the importance of the operational logs has been underscored at length. Yet, the prosecution has only translated a very limited number of pages of these logs. We wish to take this opportunity to inform the trial chamber that we will object to any request to have selected entries of these logs entered in evidence out of context. The importance of the intercept material has also been highlighted by the prosecution in its opening statement. We also take this opportunity that even though these are at least to this day, or there are, sorry, at least to this day and to our knowledge, no intercept material involving Second Lieutenant Nikolić. This material will be contested, and that this will require that intercepts not be considered à la pièce, but in the proper context. In its opening, the prosecution has referred to the differences between the functions of commander, deputy commander, assistant commander, staff officer. The prosecution has also made reference to the duties and responsibility of the security branch, as well as to the military functions of intelligence and counterintelligence. We take this opportunity to inform the trial chamber that the evidence in this case will portray a situation which is different from that described by the prosecution. And we believe that this is important for the trial chamber to know this before the testimony of any witness employed in such functions testify. Lastly, under this topic, in its opening statement, the prosecution has made reference to documents not available because they have been destroyed. This is significant. In fact, we agree that some documents are missing because they have been destroyed. Furthermore, as regards Second Lieutenant Nikolić, we will go as far as to say that the missing documents in this case will be more important than some of the exhibits on the record, especially when the time comes to assess and draw inferences regarding the conduct of Second Lieutenant Nikolić. Simply put, the evidence presented in this case will show that many of the documents from the Zvornik Brigade available have been carefully selected by one of the prosecution witnesses, and that other documents, which are important for the understanding of this case, have been disposed of, we don't know how. I now move on to my second topic of the first part, which is the identity and the character of the accused, Second Lieutenant Drago Nikolić. Again, in this regard, I join my colleague representing the accused Beara in stressing the fact and the importance of knowing the background of the accused when considering the evidence related to his conduct. So who is Drago Nikolić? To provide but a summary at this stage, it is our submission that the evidence will show the following regarding Mr. Nikolić. Born in 1957 in the village of Bana Bacici, sorry for the pronunciation, in the municipality of Bratunac. That means that he was 37 years old at the time in July 1995. He has two brothers. Well, actually, he has three because one died very young. At the age of 14, Drago Nikolić, unlike his brothers, was sent to secondary military school. That is from 1972 to 1976. He did not go to college. Immediately following high school, he began serving in the infantry. That is in 1976. Having served 8 years in the infantry, he requested to attend a basic policing course at the Military Security Training Center in Pančevo. That's a short course of 3.5 months. And that is why in 1985 he was appointed to the position of assistant in the military police with the rank of senior sergeant. A senior sergeant, this is a non-officer rank. 3 years later, because he was a good senior sergeant, he became a first-class sergeant. And in 1991, he served as a member of the military security branch at the Sarajevo garrison. Drago Nikolić is married and the father of 2 daughters. In 1990, shortly before the war, he lost his son, who died at the age of 8, which was a very difficult event. Due to the war, Drago Nikolić was sent to Zvornik, where he became assistant commander for security, a post normally occupied by an officer at the rank of major, way above his level of responsibility at the time. Because this was an officer's position, he was given the rank of second lieutenant, which he retained throughout the war. And when he retired in 1998, he still had not been promoted to a higher rank. Today, Drago Nikolić has 3 granddaughters. We respectfully suggest to you, Mr. President, honorable judges, that this information will be highly relevant as you set out to assess whether he should bear any responsibility for the events that unfolded during the 3 days for which he has been charged by the prosecutor. Of course, Mr. President, it is also important to look at the duties and responsibilities assumed by Drago Nikolić during this period. The evidence in this case will show the difference between an assistant commander and the chief of a department, such as, for example, the chief of communications. The evidence will also show the difference between the functions of intelligence and counterintelligence. To provide an idea, the intelligence officer in any military unit is there to gather information and to assess the actions of the enemy with a view to interpreting this information and providing the commander with an assessment of the strength, the weaknesses, and the likely actions of the enemy. Intelligence is a vital function in any army, as well as a highly specialized trade. As for the counterintelligence function, as indicated by its name, this refers to the measures taken to frustrate the gathering of intelligence by the enemy. It implies the search for sources used by the enemy to gather information and to take measures to try and put an end to such information gathering. We respectfully suggest, Mr. President, that the difference between intelligence and counterintelligence is highly relevant here. Why is this so? Well, simply because the 2 functions can, in some cases, be performed by the same persons, depending on the type and size of the unit or formation. This was the case, for example, as the evidence will show, for Momir Nikolić. Within the Bratunec brigade, Momir Nikolić was a security officer, and he took care of intelligence, and he took care of counterintelligence. This was not the case for Drago Nikolić. As assistant commander for security, he performed the counterintelligence function, but not the intelligence function. This is significant because in this capacity, Drago Nikolić had limited information at his disposal with regard to what was going on elsewhere within the Drina Corps. This is also significant because, as mentioned by the prosecution in its opening, counterintelligence officers do not have subordinates or personnel. Expert evidence in this trial will show and explain in detail the responsibility of security officers. Expert witness evidence will confirm that, contrary to the prosecution's assertions, security officers do not command, direct, or manage military police resources within the unit or formation. Their role is to advise the commander on the employment of the military police resources, but the commander, or in his absence the deputy commander, as was often the case in Zvolnik Brigade, retains full authority to employ the military police resources as he sees fit. In this regard, orders can be issued directly to the commander of the military police company without informing the assistant commander for security. Simply put, Drago Nikolić had no authority over the military police company and could not issue orders to a man called Jasikovac, the commander of the military police company. This, we take the view, is highly relevant here and will be shown by the evidence. In its opening statement, or maybe it is in the pre-trial brief, the prosecution stated that Drago Nikolić was responsible for all prisoners within the zone of responsibility of Zvolnik Brigade. At this time, suffice it to say that we will challenge this assertion, and expert witness evidence will demonstrate that the concept of zone of responsibility is not a term which finds application in this regard. Expert witness testimony will also establish clearly for which prisoners or persons detained the chief of security of the Zvolnik Brigade could be responsible. I now move on to topic 3 of part 1, which is the prosecution's case against Drago Nikolić. Now, no matter how we look at the latest amended indictment, it appears evident that the prosecution's case against Drago Nikolić can be found in paragraphs 42 and 80 of the indictment. To save some time, I will not quote these paragraphs, but I will simply indicate to you that they are highly similar. Paragraph 42 would be the actions of Drago Nikolić with respect to the first joint criminal enterprise, while paragraph 80 would be the actions of Drago Nikolić, much the same, for the second joint criminal enterprise. It is on this basis, 2 paragraphs, that the prosecution is asking you, or will be asking you, after the presentation of its case, to convict Drago Nikolić for all charges in the indictment, because he was allegedly a member of a joint criminal enterprise to transfer the population of both Srebrenica and Žepa, and a second joint criminal enterprise to kill a number of men and boys from Srebrenica. As we will explain a little later, and as the evidence will demonstrate in this case, even if the evidence established paragraphs 42 and 80 beyond a reasonable doubt, which we respectfully submit will not be the case, Drago Nikolić could not be found to be a member of the 2 alleged joint criminal enterprise. The prosecution's shotgun approach must also be addressed in this regard. As mentioned in our pretrial brief, it is simply not right for the prosecution to allege all possible forms of liability pursuant to the statute without stating clearly what its case is. As we can see from a number of indictments before this tribunal, Drago Nikolić's case is not an isolated event in this regard. This is like if the prosecution took a number of pieces of 1 euro, threw everything in the air, and then try to catch them, hoping, of course, that something will fall in the end. We respectfully ask you, Mr. President, honorable judges, to be critical in your analysis of the evidence as it will be produced by both parties, with a view to seeing through the overcharging policy of the prosecutor in respect of Drago Nikolić. I've been speaking for about 45 minutes, and I'm about to go into part 2. Maybe
it's up to you, Mr. Burgon, but if you prefer a break now, we'll grant you a break now.
Well, I can,
if you can move
begin
to the
on
first
the second
yeah,
part,
yes.
and once we hit 1 hour, then I would suggest
okay,
we stop.
you started your intervention at 10:35, so regulate accordingly. I mean,
thank you, Mr. President. So moving on to part 2, first topic is the applicable law in this case. Prosecution does not address the applicable law in its opening statement, but it has done so in its pretrial brief. Without spending too much time on this topic, there are indeed legal issues which we believe must be brought to the attention of the trial chamber at this stage. The trial chamber will not be surprised that the first of these issues is the joint criminal enterprise form of liability, as alleged and pleaded by the prosecution. In its opening statement, prosecution said, "We are all familiar with the crime of drugs and the crime of bank robbery. Even though this was not mentioned, it is our understanding that the joint criminal enterprise is what my colleague had in mind when saying this." And I must agree with him, which, as the trial chamber may have appreciated, is not something which happens to me too often. That drugs and bank robbery are indeed crimes well suited for the application of the joint criminal enterprise doctrine. This is the classical example. 3 persons set out to rob a bank. They each have a loaded gun. They each perform a different task or function which is part of the bank robbery. One of the 3 encounters a security guard, even if that was unexpected, and he shoots him. As a result, the 3 are convicted of bank robbery pursuant to JCE Category 1. And the 3 are also convicted of murder under Joint Criminal Enterprise Category 3, because even though the murder was not part of the original plan, it was a natural and foreseeable consequences of the implementation of the plan. Now, of course, there can be many variables added to this example, such as, upon setting out to implement the joint criminal enterprise of robbing a bank, the 3 had an unloaded gun, and this was confirmed by the 3 of them before they set out. And it's only after they left each other that one of the 3, without telling the others, loaded his gun. In this example, it could be argued that the murder was not a natural and foreseeable consequence of the joint criminal enterprise. I take the time to mention this, Mr. President, because the difficulty is trying to apply the same doctrine to a much more complex situation and to make everyone or all members of the VRS guilty, whoever they are and whatever they do, if they happen to be present in the Srebrenica area or in the Zvornik area in July 1995. When the Joint Criminal Enterprise or Common Purpose Doctrine was first used before the International Tribunal, that was in the Tadić case. Even though this was more complex than bank robbery, it could be understood why Tadić was found guilty of murder committed during an operation conducted in a village, despite the fact that there was no evidence as to who had committed these murders. The Joint Criminal Enterprise Doctrine was born. The problem is that ever since, the prosecution has been pushing the envelope again and again to expand the joint criminal enterprise liability concept to ensure that all members of any group are found guilty. In this case, it appears from the prosecution's pleading that if you are a member of the main staff, you are automatically guilty. Or, with respect to Drago Nikolić, if you are a member of the security branch or of the Zvolnik Brigade, you are also guilty. In fact, Mr. President, it appears as though we are getting into strict liability, and this simply cannot be. Not surprisingly, in prosecution circles, the joint criminal enterprise liability concept is referred to as the just convict everyone liability concept. This is why, as we begin this trial, it is important to establish clearly what elements have to be established beyond a reasonable doubt for Drago Nikolić to be found guilty pursuant to a joint criminal enterprise mode of liability. I suggest, Mr. President, that we stop here, and then I will continue to finish in less than 1 hour in the second part.
Certainly, Mr. Bougon. We'll have a 20-minute break starting from now.
Thank you, Mr. President.
All right, shall I lever. Please be seated.
Yes, Mr. Bougon, you have the floor.
Thank you, Mr. President. Honorable judges, I will continue where I left off, and that was in the overview of the joint criminal enterprise form of liability. Now, in its decision on the form of the indictment issued on, I think it was 12 or 13 July, the trial chamber partly addressed this issue and confirmed that pursuant to this mode of liability, it is not compulsory for the perpetrator to have been involved in the actus reus of the crime. We agree. However, there are other elements which must be established, not the least being the clear identification of the joint criminal enterprise or common purpose, the participation of the accused in this common purpose, and more importantly, the mens rea, and that it must be shown that the accused himself intended the crime at issue to be committed. With this in mind, we respectfully suggest that the evidence will demonstrate that the joint criminal enterprise to forcibly transfer all Muslims from Srebrenica and Žepa, as alleged and pleaded by the prosecution, does not fulfill these requirements. Moreover, in the event that a similar joint criminal enterprise was established or was focused on the right common purpose, the evidence will show that Drago Nikolić was never a party to this joint criminal enterprise and certainly never intended to further the alleged common purpose of forcibly transferring the Muslim population from Srebrenica and Žepa. The trial chamber has ruled that the latter issue, Furthermore, Mr. President, we need to address the category 3 of joint criminal enterprise. And we respectfully submit that the evidence offered in this trial by the prosecution and the defense alike will demonstrate that the opportunistic killings, as pleaded by the prosecution, were not the natural and foreseeable consequences of carrying out both common purposes, as alleged. Now, this is linked, as you probably recall, Mr. President, to a previous decision of the trial chamber for which certification was not granted, and the issue at stake was whether a joint criminal enterprise requires the physical perpetrator has an agreement with the accused, who is charged as a participant, and whether the physical perpetrator has to be a participant in the joint criminal enterprise himself. the trial chamber has ruled that the latter is an issue that will have to be addressed at trial. While we are confident that this issue will soon be determined in other proceedings before the International Tribunal, we consider it important to respectfully state, as we begin this trial, that in our view, there must be an agreement and that the physical perpetrator must be a participant himself, because this is the only way to avoid strict liability. The defense of Second Lieutenant Nikolić does not dispute, that's moving on to another topic, which is genocide, the essential elements of genocide as they have been developed by the appeals chamber of this tribunal. However, we do dispute the manner in which these elements have to be applied to the facts, not only of this case, but of every case, with a view to determining whether or not a genocide was committed. We do not believe that the Srebrenica events amount to a genocide, and we will be calling on expert witness evidence with the aim of providing the trial chamber with the necessary frame of analysis to assist it in determining whether a genocide has taken place or not. Of course, we can't speak about genocide without looking at the charge that was laid for conspiracy to commit genocide against Second Lieutenant Drago Nikolić. As was mentioned before, this is not an accusation that is a regular before the International Tribunal. And in this sense, we are somewhat entering new territory. Conspiracy to commit genocide is a charge which has been laid and has been addressed before the International Criminal Tribunal for Rwanda. So we have some kind of a reference. Although the situation which took place in Rwanda in 1994 is far different from the Srebrenica events. Regarding Drago Nikolić, we are of the view that whether or not a conspiracy to commit genocide is established by the evidence will show that he could not, did not, and certainly did not have the necessary mens rea to have anything to do with such a conspiracy. At this stage, there's only one last legal issue I wish to address before moving on to my next topic. And that is the apparent confusion which the prosecution is making between what is known as jus ad bellum and jus in bello. It can be anticipated that during this trial, again and again, the prosecution will be driving home the issue of joint criminal enterprise and the allegation that all members of the VRS were part of it. We are of the view, however, Mr. President, that a distinction must be made between the strategic and military objectives of the VRS, which may potentially be seen as violations of the right to use force in Bosnia in 1995, but that such violations of public international law or jus in bello, are not violations of humanitarian law or jus in bello, and cannot be the basis of a joint criminal enterprise. To us, this distinction will be necessary to maintain this distinction throughout this trial. I now move on to the second topic of my second part, and that is the prosecution's theory of the case regarding Drago Nikolić. As mentioned, on the basis of the allegations in paragraphs 42 and 80 of the indictment, the prosecution has charged Drago Nikolić and will ask you, after introducing its evidence, to find him guilty of the following: as a participant in the joint criminal enterprise to forcibly transfer the population from Srebrenica and Žepa, Secondly, to find him guilty of all the crimes beyond this joint criminal enterprise, alleged as being the natural and foreseeable consequences of this common purpose. Thirdly, as a participant in the joint criminal enterprise to kill thousands of men and boys from Srebrenica. And finally, of all the crimes beyond this joint criminal enterprise, which were the natural or alleged to be the natural and foreseeable consequences of accomplishing this common purpose. With all due respect for my colleagues from the prosecution, it is our submission today, as the evidence will show, that this is simply a leap too far. More importantly, that such a conclusion does not match nor fit the prosecution's theory of the case even before we set out to hear the first witness. It must be recalled in this regard some of the assertions made by the prosecution in its opening statement. First, the fact that the strategic objective of the VRS were developed and remained unchanged since 1992. Secondly, that the plan to kill the men from Popović would have been adopted by Mladic on the night of the 11th July. Thirdly, that the plan to kill all of the other prisoners would have been adopted on 12 July. And that the executions would have begun on 13 July in the morning. Number 5, that the initial decision to perform some of these executions in the Zvornik area would have been made in the afternoon of 13 July. And 6, that the information related to these killings would have reached Zvornik not before the night of 13 July. These are assertions that we will say will not be demonstrated by the evidence. But for the sake of argument, let's say they are. It is our submission today that these assertions, as a minimum, defeat the prosecution's case that Drago Nikolić was a participant in the first joint criminal enterprise. It is also our submission that whoever committed these killings in the Zvornik area, the evidence will show that this was not a Zvornik brigade-led operation, even though the evidence will show that some resources from that brigade were indeed used. More importantly, regarding Drago Nikolić personally, the evidence will show that he was not a participant in these events. More specifically, it appears that the prosecution's case, when we look at what the case is, what we've heard from my colleague on Monday and Tuesday, to find him guilty of all crimes in the indictment, appears to be as follows: a telephone conversation with the deputy commander of Zvornik Brigade, of which there is no intercept evidence; a decision by the deputy commander to relieve him from duty at the forward command post on the night of 13 July, so that he could participate. There's only one witness who will say that, and it's the person who says that he was relieved from duty. The fact that he was seen in Oraovac by some witnesses. A vehicle log which shows that a vehicle from the security traveled to some of the execution sites. But the prosecution has said they cannot and will not be able to show that Drago Nikolić was ever in that vehicle. Finally, an entry in the Zvornik Brigade log where the name of Drago Nikolić appears close to that of the accused Beara. Of course, this is not an exhaustive list of the evidence which will be presented in this trial against Drago Nikolić, but very close to it. And it is on this basis that they will ask you to find Drago Nikolić guilty of all crimes in the indictment. There is, as I've mentioned at the beginning, another side to the story. And this will be revealed by the evidence, which will leave you no choice but to conclude that Drago Nikolić is not the man the prosecution would like you to believe he is. The case for the defense will show that there was no telephone conversation between the deputy commander of Zvornik Brigade and Drago Nikolić. And the evidence will show that Drago Nikolić was not relieved from his forward command post duty on the night of 13 July to participate in these events. The evidence will also demonstrate that Drago Nikolić was not informed of the infamous plan, if I may refer to the plan this way, on the night of 13 July by Momir Nikolić from Bratuna's brigade. The case for the defense will also provide information on the whereabouts of Drago Nikolić during the 3 days for which he is now charged with genocide. Was he in the Zvornik Brigade area? Yes, he was, and the evidence will show that. Will you hear some witnesses saying that he was in the Zvornik Brigade area? Yes, you will hear that. We will have to assess where he was at what time. Having said this, and I turn to the last topic of the second part, which is exactly looking at the prosecution evidence in this case. Looking at documentary evidence, I have already addressed this issue earlier, and I've informed the trial chamber that we will be contesting the reliability of the intercept material, as well as the danger of drawing inferences from such material. To provide but one example, while the trial chamber in the Krstić case, on the basis of one intercept, concluded that Krstić was involved in a killing operation, the appeals chamber reversed this finding on the basis that the intercept used could have another meaning and that this was not enough. This applies to the interpretation of many documents, as suggested by the prosecution. We respectfully ask you, Mr. President, honorable judges, to keep in mind the other reasonable and often more plausible interpretation possible. I also take this opportunity to reiterate once again the importance of the missing documents, as well as why these documents are missing. Which brings me to the witness issue, the witness who will be called by the prosecution in this case. Of course, there are many types of witnesses that you will hear. You will hear victims, and it is our undertaking before you today that we will show the greatest of respect for witnesses who are victims of the events in Srebrenica. We will try to show compassion as best as we can, and we will try to limit our cross-examination of these witnesses. Nonetheless, the tendency of a victim to inflate numbers, something quite normal, and to say more than what really happened is something we have to be careful with. You will hear expert witnesses from both the prosecution and the defense. That's not a problem. Expert witnesses may be required to assist the trial chamber in performing its adjudicating function, as long as those expert witnesses stay within the confines of their area of expertise. And the defense will see to it that witnesses or expert witnesses from the prosecution remain within the confines of their expertise. We will hear investigators, members and staff members of the prosecution who will testify. We think that this is somewhat of a contentious issue. Then again, if these witnesses remain within the confines of providing evidence, there will not be a problem. If they try to step outside of the boundaries of evidence, then for sure the defense will be there to object. There are, of course, more important categories of witnesses. And these are, first of all, the witnesses who in some way were involved and the insiders. Let's look at the witnesses who were involved. Prosecution has said, my own witnesses will come and go. One of them is a bold-faced liar. Prosecution says the bold-faced liar witness can bring good evidence that we should keep, and we should reject what the evidence that does not fit the prosecution's case. Well, we disagree. The prosecutor will have to live with the evidence as it comes in. Many people in the Zvolnik area were close to what happened. You will hear this from witnesses. Some people may actually have seen what happened. Some people, then again, were personally involved. They're not accused, but they were personally involved in these events. To provide but one example, some witnesses will come and say, I buried those people. It's tough for these witnesses to come and say that. But all of these witnesses, Mr. President, honorable judges, have something in common. They are scared beyond any imaginable way. Because whether or not they were involved, they are scared that they may be the next people accused to appear in Sarajevo. There is a cloud which hangs over the Zvolnik area today. Something which makes it that witnesses who were in the Zvolnik area in 1995 are people who would like to forget what they saw, if they were eyewitnesses, what they learned from others, if it's just hearsay, or what they did if they were involved. All of these people are likely to have personal reasons for saying what they will say, whether it is exonerating evidence or inculpatory evidence. It will be a most difficult task for the trial chamber to try and make the choice or to weigh the evidence that will be provided by these witnesses. It may be that the prosecution will have to go through the hostile witness procedure with some of these witnesses. If it does, there are consequences to using such a procedure. The potential use of evidence provided by such witnesses cannot have the same weight and cannot be evaluated in the same way as a witness who testifies without going through this procedure. What I'd like to mention at this time is, why is it that the prosecution knows that some of these witnesses might come and go, to use the exact words of my colleagues? I'd like to show you a couple of examples simply of how these people are being interviewed when they meet the prosecution. Let me go through one example that you have on your screen. That's witness 142. And this is what we see. I'm going to ask you questions about the killing and about organization for killings of many thousands of men. But I want you to understand some things. We have part of witnesses to the killing. We have survivors who were part of the execution, who were shot at. We have aerial images. We have seized records from the Zvolnik Brigade. We've had many people from those brigades and Drina Corps interviewed. We have your MP logs. What I want you to understand is that it's very important for you to tell the truth. If you try and hide what happened, or hide your part in what happened, or your knowledge of what happened, I can prove that you're lying. And I want you to understand this, that this is your chance to tell me the truth right here and now. I let the trial chamber read the rest of this interview. And of course, I'd like, where he concludes, I'd like to give you the opportunity of telling me what happened. remembering that I have all those things, all that knowledge. We even have your vehicle logs. Now, can you tell me what you know to have happened? Let's try to imagine for a minute how a witness, whether he was involved or not, whether he saw something or not, whether he learned something by a member of his family or a neighbor, how he feels after an interview like this, and how he will feel when he will appear before your honors to testify. Let's look at another example. This is witness 125. And here we say, the witness says, and I go to the part in bold, because at my first interview, it was my first time, I was not aware fully of what this regards. And also there have been some pressures on me during my first interview. So many things have been left unsaid or incomplete. Quite a lot of things will repeat themselves. And then it goes on. The investigator says, I'll explain my position now. When you were interviewed, it was put to you that you had some knowledge of the execution. Not that you were directly responsible, but that you had knowledge of them. That some of your assets assisted in taking the men to the Dom. We have vehicle records that show vehicles, effectively going from where the prisoners were held to where the prisoners were executed. And that's not to say that you executed those men. That's to say that your troops participated in that, and I believe, and we believe, you had knowledge of that. Again, how does a witness behave? What does a witness feel when he goes to an interview like that? In some cases, witnesses were pressured as suspects. In some cases, they were not. But we will see how the prosecution tried to obtain the evidence. And this, Mr. President, we tell you, will be an important factor in assessing whether these people, these witnesses, how they will react before the trial chamber.
Mr. Bougon, could you please confirm whether when you said witness number 125 or previously witness number 140, whether these are witnesses or prospective witnesses in this trial, or whether they were witnesses in some other trial?
Mr. President, these are witnesses that are scheduled
for this trial,
on the prosecution's list of expected witnesses.
Yeah, okay, for this trial. Okay, thank you.
And I had two more examples I wanted to show you. Maybe we can quickly go through the next one just to show, not this one, another one. Next one. Okay, this one. If I can go just before we see where we have number 132. And where the investigator says, but if you're not telling me the truth, and if you're not telling me exactly where you went and what you saw, it's difficult for me to believe that you weren't further involved, that you weren't deeper involved. I'll ask you again. Did you go where the bodies were? And I'm only asking you if you were there and saw them. Let's be truthful and honest. I'll leave it at that and move on to my next issue, which is that of, as we hear these witnesses, there are things that we will have to be very careful, potential traps to be avoided. And as the defense for Drago Nikolić, we will try to do our best to ensure that we avoid these traps. And those includes opinion evidence, hearsay, and witnesses being led. All these things in some form are admissible before the International Tribunal. It's a tribunal that is different from many others in this respect. However, whether it is for hearsay, whether it is for opinion evidence, I'm talking opinion of an ordinary witness and not of an expert witness, or whether it is a procedure in leading a witness, there are procedures established in the case law of this tribunal, and the defense will do its best to assist the trial chamber in ensuring that I'm really not convinced anymore that accepting guilty pleas in such trials is a very good way to proceed. Simply because, and we will demonstrate this when these witnesses appear before the trial chamber, we will demonstrate that they had an interest in pointing fingers at others who were not there, and we will show the inconsistencies, the many inconsistencies, and the stories that do not hold the road in their testimony. These witnesses have used the guilty plea to their advantage, and they have provided information which the prosecution was looking for, which the prosecution needed, and which the prosecution indeed obtained in exchange for leniency towards sentencing. Evidence in this case will reveal that these witnesses did not tell the truth, and that such evidence cannot be used as evidence, as reliable evidence in this case. Now, as I end this opening statement, I think you will agree with me, Mr. President, that there's no surprise, there's no tactics. The prosecution knows exactly what our case will be, what we say did not take place, and what we say took place, and what we will be contesting. There's no surprise, no tactic, no strategy. Straightforward, we will try to look at the evidence as it comes in, and we are confident that at the end, after the trial chamber will be able to conclude that Drago Nikolić is not the man that the prosecution would like you to believe he is. In conclusion, Mr. President, honorable judges, first I'd like to thank you very much for your patience. If I did go through some of the law, it certainly was not to try to tell you what the law is, but simply to alert the trial chamber to some of the areas of the law that will be critical in this case. You've seen again this young lady, or maybe the old lady. I'm not so sure myself when I look at this image. By the time this trial ends, I believe, Mr. President, that you will see one of the two pictures, and that this picture will be a not guilty verdict concerning Drago Nikolić. And if today, if I have accomplished one thing of alerting you to look at the evidence from a critical standpoint as it comes in, and not to wait for the defense case, then I will have accomplished what I was set out to do in doing an opening statement at this stage. Mr. President, honorable judges, thank you very much.
I thank you, Mr. Bungon. Judge, one. Questions? No questions. Okay. Thank you.